Good afternoon, ladies and gentlemen. I'd like to welcome you to the Business Utility Subcommittee. Today is Tuesday, February the 21st, 2023. I'd like to call this meeting to order. Mr. Clerk, will you take the roll, please?
Representative Alexander, Burkhart, Clemens, Freeman, Hale, Holsclaw, Johnson, Marsh, Thompson, Vaughn, Vital, Zachary. Chairman, you have a quorum.
Thank you, Mr. Clerk. Members, before we get started today, do we have any personal orders from the committee? Seeing none, we'll go ahead and we have a couple of housekeeping things, and that's item number 3, House Bill 655 has been rolled 1 week. And item number 4, House Bill 1182 has been rolled 2 weeks. All right, we do have a calendar today, so let's go ahead and get started. And first up, item number 1 is House Bill 1342, and Representative Vital, I think you've got that one. Motion. We have a motion, we have a second, and Representative Vital, it looks like you have an amendment. Is that correct? Make sure your microphone is on, Representative.
4234.
That is what I'm showing too. And so, members, do we have a motion and a second on the amendment? We have a motion, we have a second. Does that define the bill, or do you want to, is it minor in nature, Representative? If it makes the bill, go ahead and just go ahead and present now then. You're recognized on your bill, Representative Vital.
It does. I was not prepared for this bill. I thought someone else was presenting it today.
Okay, I tell you what, let's roll this bill to the hill. All right.
I would. Appreciate it. Thank you.
Next up, item number 2, we have Chairman Faison. Motion. We have a motion, we have a second. Chairman Faison, I'm showing an amendment. What drafting code are you showing on that?
So I have an amendment drafting code 3692.
Okay, members, can we get a motion and a second? Motion. We have a motion, we have a second on the amendment. Is it minor or does it define the bill?
No, sir. Committee, the amendment makes the bill.
Okay, let's go ahead and put that amendment on the bill. Members, all in favor of putting Amendment 3692 on the bill, vote aye. All opposed say no. The ayes have it. Sir, your bill is amended, and we are back on that bill as amended. You're recognized.
Thank you, Committee. For those of y'all that were here last year, we passed a bill, became Public Chapter 680, that deals with autoclaves, that's bullers that clean medical instruments. We've had struggle implementing that bill, so after further discussions with the Department of Labor agrees that the best path forward is to exempt these devices from regulation by the Board of Buller rules. As amended, Senate Bill, House Bill 1452 does just that. First, it omits the statutory language that was added last year. Second, it defines autoclaves and miniature bullers and specifies that Title 68, Chapter 122, Part 1, does not apply to the unfired pressure vessels contained within an autoclave or to miniature bullers that are integrated as a component of a medical device.
Chairman, thank you for that explanation. Members, do y'all have any questions for the sponsor? And sponsor, I do show some folks that are here that are available. Do you need them to testify from the Department of Labor? Okay. If not, question's been called. Members, we are voting to send House Bill 1452 to full commerce. All in favor say aye. Aye. All opposed say no. The ayes have it. Sir, your bill is on its way to full commerce. Next up is item number 5. That's House Bill 988 by Representative Beck. We have a motion. We have a second. Representative Beck, you are recognized.
Thank you, Mr. Chairman and committee. Today I have a constituent-driven bill that was brought to me. In my district, the Madison Church of Christ built a senior living facility that was the brainchild of Ira North. Many of y'all remember him. And this senior facility was sold to a private company. And then, as everyone knows, the real estate market in Nashville is booming. Well, this company sold to a third company that decided that they would do better redeveloping the land. So they evicted 50 or so seniors that had no place to go. And thus, one of those people are here today. And my constituents today are Danielle Cotton, Karen Holder, and they have formed a group called Awake, advocating for wellness, accessibility, and knowledge of injustice facing the elderly. And their mother, third generation, is also here, Norma Upshaw. And Mr. Chairman, if we could go out of session in order to hear my constituents and witnesses, please.
We'd be glad to. Members, we're going out of session, and I'd like to invite Ms. Danielle Cotton and Ms. Karen Holder to come up. And be sure when you, before you speak, to make sure the microphone is turned on, and then state your name for the record. And as we discussed previously, we'll give you guys 5 minutes total time.
Hello. Hi. Good afternoon, everyone. My name is Karen Holder, and I'm the actual founder of Awake Nashville. We are a nonprofit organization, and we are advocating for mitigating displacement and affordable housing for seniors on fixed incomes. Today, I'm actually here representing 3 generations of native Nashvillians with my daughter and my mother. But I also experienced firsthand what a 30-day eviction does on seniors that are on fixed incomes. It's a rippling effect that occurred with the senior community. The first issue, of course, is that they had community there and had been there pretty much a lifetime, many decades together. So to pack up in a 30-day notice your entire life, lifetime of memories with limited mobility, few support systems, we generally became the community's access to social work on the ground because many of them didn't have family support. Luckily, my mom has us, so we became the community's advocates, and that's how we formed Awake Nashville. We know that the market here in Nashville is growing, it's developing, it's booming because, like I said, we are 3 generations of Nashvillians, so we understand development. But we also want to emphasize that we don't want to forget our seniors in this process. We want to allow them enough time, especially when they've been in community, enough time to move and to relocate and to have affordable housing. In saying that, I would like to now introduce my counterpart, which is another generation of Nashvillians, my lovely daughter, Danielle.
Hello, everyone. I'm Danielle Cotton, and I'm the co-founder of Awake Nashville. While I'm here today representing my grandmother who experienced the devastation of displacement, I realized that this was not an isolated problem, and this could very well happen to your mother or grandmother. It makes me emotional just thinking about it. I'm sorry. But given the growth that Nashville is experiencing, coupled with the lack of inventory for affordable housing, this bill is necessary for our seniors to better protect them from ever experiencing this again. Nashville, I have seen firsthand the effects of involuntary displacement trauma and how it uproots the fabric, safety net, and support system that seniors desire as they age. This is why we believe it is imperative that we extend the eviction regulation for displaced seniors from 30 to 90 days. We know that growth and development is going to happen, but we want everyone to thrive from this growth, especially our seniors, because they are the foundation and pillars of our community. We hope that by hearing from us today, you will understand and see the urgent need to move this bill forward. Thank you for this opportunity, and I hope we can gain your support in our efforts to help us better protect our seniors. Thank you.
Thank you, Ms. Cotton and Ms. Holder. Appreciate y'all speaking today. If you'll hang on, does anybody on the committee have a question for the ladies? Representative Clemens, you recognized.
Yeah, thank you, Mr. Chairman, and thank you for being here. I know it's a tough conversation and tough topic to discuss, but I'm curious. So In your specific situation, were you given the 30 days notice, and then what? That's representing Nashville. I'm very familiar how tough this market is and how tough it is for seniors to find living, especially if they have any needs, surrounding that living requirement and need. So in your situation, how long did it take you to find somewhere else? Did you have to move in with family, or what was the situation? How did that play out?
Well, my grandmother is now in Smyrna, so she's 45 minutes away from our entire family, from her safety net, which she was in Madison, and I live in Madison, and my aunt is also 10 minutes from my home and was 10 minutes away from my grandmother. And now she's not even in arm's reach. And so it was a rippling effect for our families, because a lot of times she depends on me, but I also in return depend on her to help me with my daughter. Sometimes when I need, I'm a working parent, so a lot of the times I will reach out to her for her help and support as well. So just to have to move her within such a short time frame, the only options we had were very limited, and that was in Smyrna for her. And so that entire community is spread out amongst Nashville, and a lot of them are still not in sustainable housing that they can stay in for the remainder of their lives.
Yeah. Many of them, like you said, they have had mobility issues. They had special needs. So finding one, like you said, the affordable issue was our main problem, because seniors in the market that we're in, they don't even qualify. They don't make twice the rent, 3 times the rent. So majority of them didn't qualify. So we had to find alternate housing that's not adaptable for seniors to live in. So many of them are still displaced. Thankfully, we got them all placed, but they're really displaced because they're not in a community that's conducive to senior living, which is very important for seniors. So one of the reasons our campaign and our kind of awareness is to create some more inventory, for one, for seniors and affordable senior housing. So we're working on that piece, but we need your help in protecting our seniors, at least when they're being displaced, to give them a longer period, from 30 days to at least 90 days, to pack up their entire life and find somewhere to go.
Representative Clemens.
Yeah, thank you, Mr. Chairman. Well, thank you for coming today again, and I hate that because of this, we lost you from our county and our community. It's certainly devastating, and I know how difficult it can be as having taken care of grandparents. Having them nearby, it gives you peace of mind and peace of heart. And also, I presume you have to travel down I-24, which I wouldn't wish upon my worst enemy often. So I know how inconvenient that is in practical terms and emotionally. So thank you very much for being here, and thank you, sponsor, for this legislation.
Committee, members, do we have any other questions? If not, ladies, Representative Votto, you're recognized.
Thank you, Mr. Chairman. Quick question to better understand the type of facility that was impacted in this situation by development. Mm-hmm. I'm assuming this was a residential apartment oriented towards seniors and not a residential care or assisted living facility licensed by the state of Tennessee. Is that correct?
That is correct. It was independent senior living community.
Okay. I just wanted to clarify that, because under healthcare regulations, we need the flexibility for behavioral or healthcare reasons to move people under shorter terms, and we do not operate under leases. So thank you. Appreciate it, and I'm sorry about your situation.
Thank you.
Thank you.
Members, do we have any other questions? If not, ladies, appreciate y'all coming today. We are going back in session.
Thank you.
And Representative Beck, we are back on your bill.
Thank you, Mr. Chairman. Unfortunately, I've had some associations come with wanting some changes in the bill. With the holiday, I was not able to get everybody together, so I'm going to need to roll this 2 weeks and hopefully come back with an amended bill that satisfies everyone, and I appreciate it.
Thank you, Representative. Members, House Bill 988 is rolled 2 weeks.
Thank you.
Next up is item number 6. That's House Bill 351 by Representative Hardaway. Is Representative Hardaway with us? Okay, let's roll House Bill 351 to the hill of the calendar. Next up is item number 7. That's House Bill 392 by Speaker Marsh. Do we have a motion and a second? We have a motion. We have a second. Speaker Marsh, looks like you have an amendment. What drafting code are you showing on that?
Amendment 4032.
That is what I'm showing. So can we get a motion and a second? We have a motion and a second on the amendment. Let's go ahead and get that on the bill. Members, all in favor of putting Amendment 4032 on the bill, vote aye. All opposed say no. The ayes have it. Speaker Marsh, we are back on your bill as amended, and you are recognized.
Thank you, Mr. Chairman. This bill today concerns battery-charged security fences, which are used in businesses across the country and across our state. This equipment helps deter wrongdoers from entering a business property with the intention to commit a crime such as a theft or burglary. This model of legislation will require battery-charged security fences to be regulated through the Alarm System Code when they meet certain requirements, including safety requirements. By regulating these security systems through the Alarm System Code, businesses will be able to purchase fences more easily across Tennessee and protect their property. Localities will not be able to place unneeded burdens on businesses that wish to merely provide security to their place of business. 18 states have passed similar model legislation. In order to comply with this model legislation, the security fence shall interface with a monitored alarm device, is on a property not designated exclusively for residential use, meets IECS standards, is surrounded by a non-electrical perimeter fence, and meets certain height requirements and is marked with warning signs. So what we're trying to do is come up with a new definition of security fences which are electric battery operated. So with that, I'll answer any questions.
Thank you, Speaker Marsh, for that explanation. And first up, we have Representative Thompson. You recognize.
Thank you, Mr. Chairman. Mr. Speaker, this is a preemption bill? I take it. Is that correct?
Speaker Marsh.
Well, I think it's just. I think they are having some problems in your area, which brought this on. They're not having any problems across the state other than the Shelby County area. And we're just trying to make it where it's uniform across the state. And what they're required to do is to have a perimeter fence, which the government, local government, can tell them what kind of fence to have and where to put it and all of that. This fence will be inside that perimeter fence. And so their security people think that fence is on the personal property of the business, and so they should be able to provide what they need in that inside fence.
Representative Thompson.
Okay, thank you, Mr. Chairman. So this basically, currently there are, if memory serves me right, Shelby County or Memphis, City of Memphis has a requirement that it requires building permits to build such a fence like this. Would this undo such a code like this, either for Memphis or for any other city or county?
Speaker Marsh.
I think what this will do is this will be a new section of the code book that spells out what they have to do for the security alarm fences.
Representative Thompson.
Okay. One more question. This came to light. Does it limit electrical or utility rights of way?
Speaker Marsh.
Would you repeat that again?
Representative Thompson.
Would this limit electrical or utility rights of way?
Speaker Marsh.
I wouldn't think it should have anything to do with that. These are battery operated electrical fences.
Representative Thompson.
Thank you.
Representative Clemens, you recognize. Okay. Members, do we have any other questions for Speaker Marsh? Questions being called. Members, we are voting to send House Bill 392 as amended to full commerce. All in favor say aye. Aye. All opposed say no. The ayes have it. Sir, your bill is on its way to full commerce. Next up is item number 8. That's House Bill 1494 by Representative Clemens.
Second.
We have a motion. We have a second. Representative Clemens, you are recognized on your bill.
Thank you, Mr. Chairman. I brought this legislation following the power outages that really hit hard in my community that I represent in House District 55. I include the communities of Antioch and Cane Ridge. They were hit harder than any other communities in the state of Tennessee over the holidays with power outages that began with the TVA rolling blackout and trickled on down. It was a result of a perfect storm, or multiple perfect storms, I should say. But a lot of people in my community, I just want to say, I had the benefit of having NES and TVA come to my community and do a town hall and answer a lot of questions and provide explanations, and I appreciate that they did that, and I appreciate that they came before this committee and provided even more information. The biggest concern that came away from our town hall meeting in Antioch at the Southeast Community Center was that my residents that I have the honor of representing incurred a lot of cost but as a direct result of those power outages. So when it's 0 degrees out and your power's out for 12, 24 hours, as it was in this case, you have a lot of seniors that had to be cared for. They have equipment that they rely on. So a lot of people had to literally leave their homes, move into a hotel for 2 or 3 days. Some had to go to the emergency room just to make sure that they were cared for, or to get somewhere where they could be on, life-sustaining products or any other requirements that they may have had. Families lost food that they had bought and stored for the holidays, incurred all kinds of out-of-pocket expenses. So what I did was set about drafting this legislation to really address that core concern that I heard that wasn't being addressed. All the electrical, mechanical, engineering stuff, these utilities have a duty, an inherent duty, to ensure that this mistake and these unfortunate incidents never happen again. But in designing this legislation, I thought, well, there's no way for my customers, business customers in my community, or the residents I represent, to get their money back. And so I created a claim system here with this legislation whereby utility companies, if by their own negligence or failure to maintain, repair, or secure their network equipment or property, a power outage resulted from that type of negligence or willful or intentional conduct that led to the loss or interruption of services. And again, I'm only with regard to vital services here, such as electricity, natural gas, water, or wastewater, those type of things on which we rely and need to survive in 0 degree temperatures, that those entities would have a claim system set up whereby my residents or any other resident in the state of Tennessee could seek reimbursement or a rebate against their future billing. Of course, their power's out, so they wouldn't be charged during that time period. But if they incurred out-of-pocket costs, such as hotels and additional food or emergency room expense or something like that, then they could file a claim with that utility company and have that credited towards future billing to some extent. Now, of course, that met strong resistance from the utilities industry. And I've met with them, and again, I appreciate NES and TVA and hearing from cooperatives across the state of Tennessee who I understand don't have a claim system. They don't have a refund or rebate system set up, which is what I sought to do in this instance under very specific circumstances, again, of negligence, gross negligence, or willful or wanton conduct. But I am working with them. I do appreciate their feedback on this. For that reason, I'm going to take this bill off notice, but I do want us to have a sincere, thoughtful conversation about the reliability of our electric grid. I know this concern goes across party lines in here, especially following the recent power outages, but reliability is key. And I think our utility companies are doing the best they can to keep our lights on and keep our vital utilities running and flowing for the benefit of Tennessee families. But in those instances where they fail to maintain or protect or secure their equipment, or their system, or they're just plain negligent or not giving a particular part of town the attention that it needs, the residents deserve not only answers, but they deserve some sort of monetary reimbursement or refund for the costs they incur. So with that, Mr. Chairman, I thank you for the time. I thank the utility companies for their feedback, but I will continue to advocate on this issue on behalf of the people I have the honor of representing, specifically those in Antioch and Cane Ridge who suffered the hardest during the recent blackouts. And we'll continue to work on this issue, and I hope the members of this committee will assist me in potentially evaluating how best to address this and moving forward. So thank you, Mr. Chairman. I appreciate it.
Without objection, House Bill 1494 off notice. Which brings us back up to item number 1. That's House Bill 1342 by Chairman Vaughn. Chairman Vaughn, you are recognized.
Thank you, Mr. Chairman, and with your indulgence, I'll just stay.
We have a motion, we have a second, and Chairman Vaughn, do we have an amendment on that?
Yes, sir, we sure do. Drafting code 4234.
That is what I'm showing too. We have a motion. Do we have a second on the amendment? We have a motion. We have a second. Let's go ahead and get that amendment on there, members. We're voting to put Amendment 4234 on House Bill 1342. All in favor say aye. Aye. All opposed say no. The ayes have it. Chairman, we are back on your bill as amended. You're recognized.
Thank you, sir. And Mr. Chairman, I'm happy to present this bill on behalf of our Speaker, Speaker Sexton. Everyone deserves a free and fair election. And the best way to ensure that is secret ballot. What this bill proposes to do is that as we evaluate companies for economic incentives, that they are, in order to qualify for those, we're adding a qualification performance factor in there, is that any vote for union representation follows a secret ballot process. That means that union card checks would not be allowed. It would be simply a secret ballot. Then if the company voted to unionize, they still receive their incentives as a result of the secret ballot. So this isn't an attempt to sway that. It's simply a measure which would allow for employees to decide via secret ballot box whether or not they are represented by a union. And with that, I'll open it up to any questions.
Thank you, Chairman. Members, you've heard the explanation. Do we have any questions for Chairman Vaughn on the bill? If not, members, we are voting to send House Bill 1342 as amended to full commerce. All in favor say aye. Aye. All opposed say no. The ayes have it. Sir, your bill is on its way to full commerce.
Thank you.
And that brings us back to item number 6. That is House Bill 351 by Representative Hardaway. Representative Freeman?
Freeman.
Yeah.
Thank you, Chairman. He stepped in and said that if, he'd like to roll this 1 week.
1 week.
Okay.
Without objection, House Bill 351 is rolled 1 week. Members, that concludes our business for today. So without objection, this meeting is adjourned.